Hello, everyone, and welcome again to We the Podcast, where we examine today's issues through the lens of the English, where we examine today's issues through the lens of the United States Constitution, breaking down its structure, its original intent, and how our founding fathers designed our government to function. Because in a constitutional republic, the final safeguard of liberty is not a president or court, but an informed and engaged citizenry. Sorry, I have a little bit of an echo on my end. I'm just fixing that real quick. All right, so tonight we are going to be speaking about the legislative branch. This is not a partisan discussion. It never really is on this show. It is a structural one about the constitutional intent, and each episode asks whether our governing institutions are operating the way that the Constitution requires, and whether the allocation of power still reflects the framework that the founders had established. So to open up, I have a quote from James Madison. The accumulation of all powers, legislative, executive, and judiciary, in the hands of of the same hands may justly be pronounced the very definition of tyranny. This is James Madison in Federalist 47. And I'll say it one more time. The accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. There is something many Americans recognize, even if they struggle to articulate it. I just stumbled over it myself. Congress still meets, it still debates, it still records votes, yet many of the rules that shape economic life, education policy, healthcare mandates, environmental regulation, financial reporting, labor standards, energy, and countless other areas of daily life do not appear in concise statutory language drafted by elected representatives. They often emerge later through administrative rulemaking. Instead of defining specific obligations in detailed statutes, Congress increasingly passes expansive multi topic legislation that sets general direction and authorizes agencies to determine the substance in practice. The public sees the vote. The regulatory system develops the details. This pattern did not arise suddenly. It developed gradually over the 20th century and solidified over the decades. During the Progressive Era, a new theory of governance gained influence. Woodrow Wilson and other reformers argued that modern industrial society required permanent administrative expertise. They viewed that administration as a technical function that should be insulated from ordinary political pressures. They believed that lawmaking would set broad policy goals and trained officials would carry those goals into effect. World War I expanded centralized federal management in response to a national emergency, the World War. Temporary boards and agencies coordinated production, transportation, and labor. Although some of these structures dissolved after the war, the concept of centralized administrative control had taken root. The New Deal accelerated that development. Franklin Delano Roosevelt, his response to economic crisis produced dramatic increase in permanent federal agencies. These agencies were not designed as temporary emergency measures. They became lasting components of federal governance. Over time, administrative rulemaking became a normal method of producing binding rules. What began as crisis management gradually became institutional habit. The Constitution contains no general grant of emergency powers. It provides specific enumerated powers and a defined amendment process. The founders understood that temporary expansions of authority, once accepted, are difficult to reverse. As Thomas Jefferson observed, the natural progress of things is for liberty to yield and government to gain ground. Temporary discretion became standing authority. Detailed statutes gave way to broad frameworks. Comprehensive authorization became more common than narrow tailored laws. Instead of resolving specific regulatory questions through new legislation, Congress increasingly relied on agencies to refine and expand policy for them over time. This episode will examine how that transformation occurred, how omnibus bills facilitate it, how delegation operates in practice, and why the rise of what I describe as the bureaucratic or administrative branch raises serious constitutional concerns. But before we get into the substance of tonight's episode, I just want to thank you all again for supporting the podcast. If you value these serious conversations about the Constitution, please take a moment to subscribe, like, follow the podcast, and share this episode with someone who cares about how our system is designed to function. You can also find my book, The Last Republican, Thomas Massey and the Death of the Party, on Amazon, Barnes & Noble, and Apple Store. The links are in the description. And as you listen, consider leaving a comment to share what you find most interesting or what you've learned in this episode or even episodes past. Thoughtful discussion strengthens the purpose of this platform. So to get this started, what was Congress designed to be? To understand what has changed, it is necessary to understand what Congress was designed to be. Article 1 of the Constitution vests all legislative powers in Congress. The language is clear and comprehensive, placing the authority to make binding law in one identifiable institution. Lawmaking authority includes defining legal obligations, establishing rights and prohibitions, levying taxes, appropriating funds, regulating commerce, imposing tariffs, defining crimes, funding programs, declaring war. These are all core powers of national governance. They determine what citizens may do and what they must do, and what consequences follow from violation. The founders placed these powers in a representative legislature, composed of members regularly accountable to the people, rather than concentrating themselves in a single executive or in a body of appointed experts. Congress was structured to make law deliberated and deliberate. Legislation requires agreement of both chambers and the president's signature before it becomes law. The House of Representatives answers directly to the people every 2 years, and the Senate was originally designed to be a representative of the state and provide long-term stability. The requirement that both bodies agree forces negotiation across different constituencies and perspectives. The structure operates as a safeguard. It slows the process intentionally. It requires public debate. It requires amendments. It requires recorded votes. Law that survives that process reflect sustained agreement rather than momentum or a momentary enthusiasm, Recorded votes were central to the system. If Congress enacted a new tax, the vote could be identified. If it imposed a regulatory scheme, the vote could be traced. If it declared war, the decision would rest on the specific authorization adopted by identifiable representatives. The design assumed that those who write binding rules would stand behind them. The connection between law and legislator was meant to remain clear. The statutes were expected to define obligations with enough precision that responsibility could be traced to identifiable votes. Congress was therefore expected to define the rules themselves, not simply announce objectives and leave the substance to others. For much of the early republic, lawmaking reflected that expectation. Over time, after World War I, however, the incentives surrounding legislation began to shift. Congress gradually moved away, drifting detailed rules towards establishing broader frameworks. So, why did the incentive change? The structure of Congress remains the same, but the political environment surrounding it evolved. As federal policy expanded into more technical and specialized areas, legislation became more complex. Members were increasingly asked to vote on matters requiring detailed subject matter expertise. Rather than drafting highly specific statutory schemes, Congress began relying more heavily on broad authorizations. These authorizations established policy direction and funding levels while leaving the technical details and standards and implementation details to executive agencies. This approach offers practical advantages, and it also allows large coalitions to form around shared objectives without revolving every operational disagreement during floor debate. Members can agree on general goals even when they differ on precision regulatory mechanisms. Omnibus legislation reinforces this practice. Combining multiple policy areas into a single bill enables negotiation across issues and interests. Votes are cast on comprehensive packages that reflect compromise across numerous subjects. The detailed execution of those policies is then handed through administrative rulemaking again. Over time, the division of labor becomes routine. Congress focuses on program creation, funding, and high level statutory language. Agencies, however, focus on drafting the standards, defining compliance obligations, and administering enforcement. Congress has not stopped voting, but what's changed is what Congress votes on and how those votes function. Instead of deciding many of the detailed rules, it increasingly votes on broad authorizations and funding. So, how do omnibus bills enable the bureaucratic branch? Omnibus bills represent more than legislative convenience. It marks a shift in the mechanics of lawmaking itself, altering not only how statutes are enacted, but also where practical authority resides once those statutes take effect. A traditional statute defines rules directly in statutory text. It states what is required, what is prohibited, and what penalties attach. An omnibus bill, in contrast, often establishes the programs, allocates the funding, and outlines regulatory authority, but it delegates all of the fine details to those executive agencies. Members can now cast a single vote on legislation that may span hundreds or thousands of pages and cover numerous policy areas. Within that legislation are provisions authorizing agencies to issue regulations that carry the force of law. That statutory language frequently uses general terms, leaving agencies to determine the thresholds, the standards, the timelines, and enforcement mechanisms. Once enacted, the practical work of governance moves into the administrative process. Agencies draft proposed regulations, they publish them for notice and comment, they review submissions, they revise the language, and issue final rules. Those rules define compliance obligations in detail. They specify reporting requirements, technical standards, and documented procedures. And they also establish the penalty structures. Although grounded in statutory authority, their specific content is not separately debated or voted on by Congress. So all of these rules, all of these obligations, the fines, the penalties, the structure that these administrative agencies have come up with, they are not voted on by Congress. In many instances, the regulatory framework that develops under a single statute far exceeds the length of the specific intent of the statute itself. Entire sections of the code of federal regulations may arise from a few pages of statutory text. Businesses, local government, and private citizens must comply with these regulations as binding law. This process alters the center of practical decision making. Congress establishes objectives and provides authority. Agencies translate those objectives into operational rule. Over time, expertise, institutional memory, and policy development become concentrated within administrative bodies rather than within the legislative branch. This is what I describe as the fourth branch of government. It does not appear in the constitutional text and was not created as a co-equal branch. The Constitution establishes a legislative branch in Article 1, an executive branch in Article 2, and a judicial branch in Article 3. It does not establish an independent administrative lawmaking authority. Although agencies are formally located within the executive branch, their functions extend beyond carrying out clearly defined statutes. They issue rules that carry the force of law. They investigate and enforce compliance. They resolve disputes through internal proceedings and conducted by administrative law judges or agency officials acting as judges. In constitutional terms, administrative agencies were never intended to function as independent sources of law. Their proper role is executive in nature, to enforce statutes that Congress has written with sufficient clarity to guide execution. They were not designed to serve as primary policymakers or as bodies that generate binding standards beyond those expressly enacted by the legislature. In practice, however, many agencies do far more than simply enforce clearly defined statutory commands. When Congress drafts broad legislation and leaves key terms undefined, agencies supply the governing standards through their own regulation. They determine what statutory language means in application. They expand policy through interpretive rules and guidance, and they initiate enforcement action based on those interpretations. All of that within their own administrative tribunals. The same institutional body that writes the rules, enforces the rules, and renders judgment under the rule. The cumulative effect is the consolidation of functions that the Constitution distributes among three separate branches. Although agencies are formally housed within the executive branch, their operational role often extends to the rulemaking that resembles legislation and the judiciary that resembles the judicial authority. Bureaucratic structure exercising elements of legislative, executive, and judicial power within a single administrative framework. And that is why I opened the episode with James Madison's quote from Federalist 47: "The accumulation of all powers, legislative, executive, and judiciary, in the hands of one may justly be pronounced the very definition of tyranny." So, what does delegation do in this system? Delegation is the mechanism that allows the administrative state to expand once omnibus legislation establishes the framework. Modern statutes frequently contain provisions authorizing agencies to issue regulations necessary to implement legislative objectives. These provisions are often written broadly, as I mentioned before. In practice, this means that the statute establishes that framework while the agency defines everything. The statute may declare that a certain activity must be regulated for safety, fairness, or environmental protection. The agency then determines how exactly to implement those thresholds. Delegation also affects how statutes evolve over time. When Congress writes detailed law, changes require new legislation and new votes. When Congress writes broad law, agencies can revise regulatory standards through updated rulemaking, reinterpret statutory language, or issue guidance documents that alter compliance expectations. The formal statute may remain unchanged while the regulatory environment shifts significantly. And when that happens, the original intent of the broad legislation isn't even being followed anymore. Agencies also control that enforcement strategy, as I mentioned. They decide which violations receive priority, how penalties are calculated, and when settlements are appropriate. Through consent decrees, negotiated agreements, and administrative judiciary, agencies influence the practical meaning of all statutory commands. Dispute resolution further expands administrative authority. Many regulatory disputes are handled within the agency itself before reaching Article 3 courts. Administrative law judges or agency officials acting as judges interpret their own agency's regulations and apply them to each individual case. Judicial review is often limited to accessing whether the agency acted within statutory bounds or followed proper procedure. Over time, this combination of rulemaking, enforcement, and internal judiciary consolidates practical authority within administrative institutions. Congress retains the formal power to legislate, but agencies exercise ongoing control over how statutory mandates operate in daily life. When statutes are drafted broadly and agencies determine their meaning in practice, the center of operational authority shifts away from Congress. The constitutional allocation of power remains the same on paper, yet the day-to-day production and refinement of binding rules occurs within the administrative system. So why does this raise a constitutional problem? Before examining the consequences, we need to return to the principles. Article 1, I need to reinforce this. Article 1 vests all legislative power herein granted in a Congress. The word all is comprehensive. Legislative authority includes taxation, appropriations, tariffs, regulating commerce, all of it. I mentioned it before, I'll mention it again. Congress decides all of this. They vote on it, they debate it. That was the intent. These are the core governing powers of the national government, and the Constitution places them in the representative legislature for a reason. That allocation is exclusive. The Constitution provides only one mechanism for changing where those powers reside, and that is the amendment process. It does not authorize Congress to transfer any of its powers, any of its authority elsewhere through ordinary legislation. Legislative power, by definition, is the authority to prescribe binding rules of conduct for the nation. When Congress delegates broad discretion to administrative bodies to determine the content of those rules, the practical exercise of the legislative authority begins to move outside of the institution in which the Constitution placed it. Legislative power, by definition, is the authority to prescribe all of these rules. At this point, the constitutional issue should be stated plainly. The Constitution does not vest lawmaking authority in Congress as a matter of tradition or etiquette. It vests the authority in Congress as a matter of constitutional design. When Congress transfers broad authority to administrative bodies to decide the operative rules, it changes how legislative power is exercised in practice. The problem is not that agencies perform administration. The executive branch must administer. The problem is the scope of discretion that modern statutes often confer. When statutory language authorizes an agency to determine what is reasonable, necessary, appropriate, or proper, or in the public's interest, without clearly limiting standards, the agency is not merely exceeding a rule, it's defining the rule. That creates two major consequences. First, it weakens accountability. A statute adopted through Article 1 is attributed to A statute adopted through Article 1 procedures is attributed to identifiable legislators. A regulatory regime produced through delegated discretion is insulated from direct electoral consequences. Citizens may disagree with a rule, but they cannot remove the rule or the rulemaker at the ballot box. Congress can claim it merely funded a program or endorsed a general purpose, while agencies determine the detailed obligations that carry legal force. Second, it blows the separation of powers. A constitutional system divides the power to make law, the power to enforce law, and the power to judge disputes under the law. Administrative governance often combines those functions. When an agency issues, investigates, and enforces their own regulations, even the judicial review exists. The practical reality is that the agency's interpretation and process shape outcomes long before a federal court ever becomes involved. This is why delegation is not a technical complaint. The founders designed a system in which lawmaking would be public, contested, and politically accountable. Precisely because the power to bind the public through law is the most consequential power a government possesses. When Congress writes broadly, the constitutional structure loses all of its power. The governing authority will shift in practice. And that's the central concern of this episode. When legislative authority is exercised indirectly rather than directly, the practical character of governments changes in measurable ways. This alters institutional incentives. If detailed policy outcomes will ultimately be refined through agency interpretation, members of Congress face reduced pressure to resolve every substantial disagreement in statutory text. Over time, this dynamic produces cumulative effects. The volume of regulatory law expands without corresponding legislature, no debates. A short statutory provision may generate hundreds of pages of regulation. Policy stability becomes tied to administrative continuity. Agencies develop internal expertise. Long-term regulatory agendas become institutional memory. Even congressional majorities change. Oh, even when congressional majorities change, the administrative infrastructure remains in place. Public accountability also becomes more diffused. When a regulatory requirement imposes costs, citizens often confront a complex chain of authority. None of these developments in themselves violate constitutional text in their face, but the fact that the agencies are writing these regulations is in direct contrast to the Constitution. Agencies still cite statutory authority, but that authority should not exist under the Constitution. Courts still review agency action, yet the fundamental center of lawmaking authority has moved too far away from the chamber in which all legislative powers was vested. The structural consequence is not the disappearance of Congress, but gradual transformation from a body that defines rules, binding rules, and detail to one that authorizes broad regulatory systems. The question, therefore, is not whether Congress still exists or still votes. The question is whether it continues to exercise legislative power in the manner that the Constitution presupposes, directly, specifically, and with clear political intent. At its core, this episode addresses a fundamental constitutional problem. Legislative authority that the Constitution places exclusively in Congress is increasingly exercised through administrative institutions that were never intended to function as lawmaking. It requires us to examine not only the failures of Congress to exercise its responsibilities, but also the legitimacy, necessity, and purpose of permanent bureaucratic structure that now writes rules, enforces them, and judges the disputes under them. The Constitution established a republic in which the power to create binding law is placed in the legislature, and that legislature is supposed to be accountable to the people. That design ensures that when rules are written, they will be traced back to the votes casted by elected officials who must answer to their constituents for their decisions. When Congress increasingly relies on broad statutory framework and delegates substantial discretion to administrative bodies, the structure of government no longer operates in a constitutional manner. This does not occur through a single dynamic change. It occurs through gradual legislation. It occurs gradually through the way legislation is written and authority is distributed Each statute that leaves core policy questions unresolved transfers practical decision making to administrative institutions that operate outside of constitutional authority. The question raised by this development is straightforward. Whether Congress will continue to exercise the full legislative authority placed in its hands, or whether it will continue to delegate the authority away. The Constitution does not require new powers to address this problem. The power already exists. What is required is the willingness to use them, to write law with precision, to resolve policy disputes within the legislative process, and to accept responsibility for the consequences of those decisions. The Constitution provides the structure. Whether that structure remains meaningful depends on whether the legislative branch continues to fully occupy the role that it was created to perform. So if you find this discussion helpful, please consider sharing this episode with someone interested in how the constitutional structure shapes our way of government. And if you can support We the Podcast by following the show, subscribing on your platform of choice, and sharing the episodes that you believe contribute to a serious conversation about constitutional government, please give this episode a follow, share the podcast, and for those who want to explore further, check out my book, The Last Republican. I do not have much more time tonight, so I have to cut it a little short. Thank you for listening.